Yes.
Lordship, for item 21, up-to-date CD has not been received. So there's an interim.
Item 21.
Yes, Lordship.
As prayed for by MS M. Das, Learned Counsel for the petitioner, lists this matter on
22nd of April.
22/4/2024. Yes, next.
Lordship, there's an interim order.
Interim, if any, shall continue till then.
Obliged, Lordship.
Right, please, Your Lordship. I'd like to mention item 33.
33.
CD is not available.
Yes, CD. As prayed for by MS
P. Naidin
P. Naidi
on behalf of D. Major.
on behalf of Mr. D. Mehdi, Learned Counsel for the petitioner, lists this matter on
On my lord, 4th of April.
4/4/2024. Any interim is there?
No interim.
Next.
Your Lordship,
My lord, in this case, my lord, earlier this is wrongly listed for motion, my lord. Earlier case diary was called for, today CD not received.
Await CD, list on
Your Lordship, can it be at 2 today? Can it be at 2 p.m.?
Sorry, I cannot hear you.
Your Lordship, can it be at 2 today?
CD not received, my lord.
List on Mr. Bhattakur,
On my lord, 1st of April, my lord.
1/4/2024. Next.
Shortly, please.
Yes. This also, I think,
yes, in
why
this case also,
all these matters have been wrongly listed.
But in this case, my lord, as per my instruction, my lord, I have got a search sheet submitted already in this case.
Shall she submitted?
Submitted.
Heard Mr.
M. Mondal.
M. Mondal, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Bhattakur, Learned APP for the state respondent. Stop. This is an application under section 439 of the Code of Criminal Procedure 1973 for release on bail of the accused petitioner accused petitioner who was arrested on
21/2, Lordship.
21/2/2024.
Yes, lordship.
On 21/2/2024 in connection with Palton Bazaar Police Station case number 56/2024 registered under section 366 IPC. Stop. The case of the prosecution is that on 19/2/2024 at about 6:30 p.m. the petitioner took his daughter with him by giving some false assurance,
366.
and since then her mobile was found switched off. Stop. Girl recovered.
Recovered, Lordship.
My lord, regarding that, my lord, recovery, I have no instruction. So let him appear before the trial court. Trial court will
No,
consider
this
it
is
according-
bail. He's already there.
Forwarding report, Lordship.
This is a bail application.
Oh yes, sorry, my
So
lord.
investigation is completed. We'll release him on bail.
Yes, well, then his statement may be recorded that girl already
Lordship,
recovered.
forwarding report, Lordship. Page
Where is the forwarding report?
13, Lordship. Page. Ground of arrest, Lordship.
The victim, minor girl, has been recovered from the possession of the.
It appears from the stop. Then you say, Miss. It is submitted. Sorry, Mr. P. Bhattakur, Learned APP, Assam submits that in the meantime, charge sheet has been submitted with a CS number
CS number
47/24
24 dated 26 to 24.
26 to
24.
24. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the forwarding report dated 21/2/2024 enclosed as Annexure 2 to the bail application that the victim girl has in the meantime been recovered. Stop.
But forwarding report para 3 also, your lordship may kindly peruse, 13, page 13, because victim is minor, my lord.
It further appears that the statement of the statement of the victim has also been recorded. Stop. It further appears that the investigation of the case is completed. Stop. As such, this court is of the considered view that further detention of the petitioner may not be justified. Investigation is completed.
Yes, my dear.
May not be required, not justified, may not be required. Stop. Accordingly, it is provided that in the event of, provided that the petitioner shall be released, petitioner named above shall be released in connection with the above noted case on bail, furnishing of bail bond of rupees 30,000. Satisfaction?
CGM Kamrup Metro.
CGM Kamrup
Metro.
with subject to the following conditions. Disposed of.
Maybe lost. 439 application, my lord, the petitioner arrested on 7/3/2023.
Sorry?
And the FR page 8.
Just one second. Add one more thing that it further appears that there is nothing adverse as regards the antecedent of the petition. Yes.
Page 8, FR, my lord.
First time.
8, my lord.
First time.
Yes, my lord. First time, my lord.
CD.
CD.
Fix on
On my lord, 5th of April, my lord.
5/4/2024.
Jalukbari, my lord.
There are holidays.
Is already released on
The only
bail, my
thing
lord.
there are holidays. Yes, Mr. Bhattakur. 5 or
Already-
earlier.
is already released on bail, my lord.
Yes, on 2nd.
Second. Next.
I love next.
304B.
Yes, Lord. CD may be called for along with
CD list on
5/4, my lord.
5/4/2024.
Braga or Moriga, part of
Next. Yes, Mr. Datta.
Yes, Lordship.
Yes. First time.
Yes, Lordship.
CD.
Co-accused is already on bail, Lordship. So order is at page 16, Lordship.
Call for CD list on
9/4, my lord.
earlier. Co-accused is on bail.
Yes, Lordship. Today is 76 days.
My lord, 4/4.
4/4. 4/4/24. Yes.
My lord, with all respect, my lord. 306 case diary, my lord. Only, my lord, 18-year-old boy, Delhi Public School. Can it be on Friday, my lord? And girl is elder in age, my lord. She committed suicide.
Call for CD list on Mr. Bhattakur.
Yeah, নাহিলেন মুখ নহব
Friday, আপনার তারিখটো কি বলুন?
22
22nd.
22nd.
Yes,
When?
on my lord,
22/4/2024.
Highly obliged.
22/3/3/24.
Highly obliged.
Yes. 3. Yes, Mr. Ghosh, transfer.
transfer here.
Sorry, Dr. Sharma.
Kamrup to
Kamrup to?
Jorhat or Shivsagar.
So notice has to go. Heard Mr. R. Sharma. Sorry, Dr. R. Sharma, learned counsel for the petitioner. Stop. Also heard Mr. P. Bhattakur, learned APP for the state respondent. Stop. This is a
State is not party.
state is not a party. State cancel. Huh? This is an application under section 407 of CRPC for transfer of FC criminal case number 734/2023 from the court of the learned principal judge family court Kamrup within bracket M at Guwahati to the court of session judge Jorhat. Correct? Or Sibsagar. Stop. Issue notice returnable 2 weeks. Registered post AD within the course of 2 days, within the period of 2 days. List accordingly.
Obliged.
None appears for the petitioner when the matter is called. List after 4 weeks and a date to be fixed by the registry. None appears for the petitioner when the matter is called. List after 4 weeks and a date to be fixed by the registry. Yes.
Better maybe the first week of April.
As prayed for, list this matter in the first week of April.
I am for 10 million.
Huh?
First week of April.
First week of April on a date to be fixed by the registry.
My lord, this is relates to my lord. This is relates to the forest department. Offense report has been filed by the forest department. So, standing counsel for forest may be shown in the court.
The name, yes, D. Gogoi's name is there.
Oh yes, 10, no, on 10 it is.
The name of the Standing Council Forest Department be reflected in the cause list.
I put 11, my lord.
Yes. In item number, you are appearing in item number 11.
11.
So it will be coming up on the same day. All right.
Both are tagged below.
Yes, it's tagged. Next.
May I please, Lordship? So this is 438 application, Lordship. Can this case
CD available?
No, Lordship, it's a motion, Lordship.
Oh, motion.
And Lordship, my name is not in the FIR, Lordship, and already I have, for a moment, Lordship, page number 19.
395.
Lordship,
Where is the FIR?
FIR page, Lordship, 12, Lordship.
Yes.
12. And very long FIR, Lordship.
My tree.
Battle not, Lordship. Ereka not.
Sorry?
Ereka not, Lordship. 250 bags. My name is not in the FIR, Lordship, and already.
Very well, let him appear.
Lordship, the amount is huge amount, Lordship.
So his name is not there in the FIR. Is his name there in the FIR?
No.
Ms. Begum?
Lordship, no, it's a big FIR, Lordship. No. CD, Lordship, will be short date, Lordship. Short date, because amount is.
No, but is his name there in the FIR?
No.
If his name is not there, then let him appear. In item number 12. Heard Mr. F. Hawk. Mr. F. Hawk, Learned Counsel for the petitioner. Stop. Also heard MS A. Begum, Learned APP for state respondents. Stop. This is an application under section 438 of CRPC 1973 for granting pre-arrest bail to the petitioner in connection with Dharamtul PS case number 8 of 2024. Stop. The case of the prosecution is that one person, is that an FIR was lodged on 8/2/2024 alleging inter alia that the informant attached vendor counterized vehicles bearing registration number UP85BT4324, which was placed at the door of Supari Traders, 2324 Rupahi Thana Road. Stop. It is the further case of the prosecution that on 6/2/2024, the aforesaid bags of Erica nuts weighing 15,000 kgs were picked up, were left at Karnataka.
Logout to Karnataka.
Huh?
Logout to Karnataka.
Where were left at Karnataka. Stopped. It is the further case of the prosecution that after crossing the Roha toll gate, 12 unknown persons suddenly attacked and hijacked the vehicle with driver along with them to the nearby place and transferred all the goods in another vehicle. Stop. Accordingly, a case has been registered. So no names have been given as of now.
Lordship.
In order to consider the prayer for pre-arrest bail, case diary shall be required. Stop.
Lordship.
Accordingly, call for case diary. List on
April 25th, Lordship.
25/4/2024.
In the meantime, Lordship.
No. Next.
Otherwise, Lordship, short date, Lordship, can it be?
Short date, Lordship.
Before 5/4, Lordship.
Yes, Mr. Das.
Well, I think 13 and 14 are similar.
Are similar.
Similar. Whereas case diary is here. If your Lordship will please to.
Case diary is there.
Is there?
This is for the first time it has come, 13 and
No,
14.
it has come for the first time, but co-accused have been released on bail.
I have to inquire, Lordship,
Yes,
after
ma'am.
some time, Lordship.
After some time. At 2 o'clock.
At 2.
At 2.
13 and 14, both at
13
2.
and 14.
May I please, Lordship? Lord, the allegation under section 376.
376, yes.
Subsequently, Lordship,
CD, Lordship.
I have let the informant party, Lordship, because subsequently they have settled the matter.
Allegations there. CD, list on
List on, Lordship, 22nd of April, Lordship.
22/4/2024. Next.
Second.
22.
Please,
Yes.
I am on behalf of Mr. N.K. Kolita, my lord.
Yes. KN Kalita.
K.N. Kolita, my lord, sorry. My lord, here it is case, my lord, lordship, English translation is very poor, my lord, so I am taking your lordship to the page number 13, my lord, Vernacular affair. Here, my lord, the landlady and her daughter is before your lordship, my lord. And incident happened in their rented house, my lord.
Yes.
On 6/6/3/2024, my lord. Lordship will find the FIR at page 13, my lord. May I read the
Yes,
FIR?
read.
বিনীত নিবেদন এই যে আজি মই ব্যৱসায়ৰ কাম লৈ 6/3/2024 তাৰিখে ISBTৰ পৰা জালুকবাৰীলৈ আহোঁ। জালুকবাৰীত মই ব্ৰিজৰ তলত ৰৈ থকা অৱস্থাত মই ছোৱালী এজনীক দেখোঁ। সেই ছোৱালীজনীয়ে মোক ঘৰলৈ লৈ আহে আৰু নিজকে বিলকিছ বুলি চিনাকি দিয়ে। আমাৰ দুটাৰ মাজত কথা বতৰা হোৱাত তেওঁ মোক গাড়ী লৈ থকালৈ দেৰি হৈ যাব বুলি কয় আৰু মোৰ ঘৰত চাহ খাবলৈ
Allegations are very bad, Lordship. CD
No, no,
will
no.
be required.
লৰ্ডশ্বিপ কালি চিধা চাহ খাবলৈ আৰু ঘৰৰ মানুহৰ লগত চিনাকি হ'বলৈ আমন্ত্ৰণ জনায়। ময়ো বেছি নাথাকি ঘৰৰ ওচৰতে বুলি কোৱাৰ কাৰণে তেওঁলোকৰ ঘৰলৈ যাওঁ। তেওঁৰ ঘৰ আচলতে ভাড়া ৰুমে আছিল। ইন দেট ৰুম, মাই লৰ্ড, এজ পাৰ এলিগেশ্যন দেট another boy and that girl, my lord, tried to my lord.
Lordship,
They
where the
demanded money and all this. My lord.
All
This
right.
lady,
Short date. CD.
my lord. My short date, my lord. This is a landlady, my lord.
Lordship on 5th of April, Lordship.
5/4/2024.
Hello.
Please, my lord, my senior Mr. Samaria mentioned it to yesterday for tomorrow, Lordship, but it wrongly come up today, Lordship. That's why he needs some preparation, Lordship.
May I
A
please-
list tomorrow.
Lordship, may I please, your Lordship, we have appeared on the last occasion, that is fixed on 12/3. Lordship, the case may be fixed on 27, Lordship. Tomorrow will
No,
not
but
be.
he is submitting that yesterday this matter was
Yes,
prayed
Lordship.
and this court allowed fixing it day after.
Yes,
But
Lordship.
today it has been wrongly listed.
Lordship, the-
So let it come tomorrow, then you.
If they have no problem, do you
No,
have
no,
any
Lordship,
problem on
we have some
27?
emergency, Lordship, urgency, Lordship.
No, Lordship, on the last occasion, Lordship, oral direction was given to the petitioner to serve us the
Actually,
copy of
this
the
matter
petition. It was not
still
given.
moved, Lordship.
It was not given. On the last two dates, kindly see, Lordship.
But this
the
matter,
petitioner has taken
this
time.
matter has not come yesterday.
Lordship, yesterday we mentioned it, Lordship, for listing, Lordship, and this honorable court allowed our mention for
For
tomorrow.
listing.
Yes, Lordship.
Okay, let it come day after. In the meantime, you give them a copy and then you make a prayer on that day, because since there is already an order
Yes.
tomorrow.
On 27, Lordship. 27.
27, then let it be on 27. First, your name?
N. Chaudhary.
MSN Chaudhary, Learned Counsel for the
Respondent
respondent
number
number.
two.
Respondent number 2 submits that the petitioner has not supplied a copy of the
In spite of the direction.
supply a copy
petition,
of
criminal,
copy of the
petition.
criminal petition despite directions of this court. Stop. let a copy of the criminal petition be served immediately upon so and so. List this matter again on 27
March.
3/2024.
Highly appreciated.
Criminal revision petition.
May it please your lordship.
Yes.
This is a criminal revision challenging the order of framing charge. The allegation is of 306. Lordship comes to the FIR, it's at page 20, the vernacular.
FIR at page
20, the vernacular. Page 20.
Yes.
FIR is lodged by the father of the deceased. সন্মানপূৰ্ব বিনীত নিবেদন যে এজাহাৰকাৰীয়ে জনাও যে কৃষ্ণা কাকতি মোৰ ডাঙৰ ছোৱালী হয়। আজি দিনৰ অনুমান 12 মান বজাত মোৰ উক্ত ছোৱালীজনীয়ে থকা ঘৰৰ বিছনাৰ ওপৰত থকা ফেনত গামোচা কাপোৰেৰে চিপ লগাই মৃত্যুবৰণ কৰে। মোৰ ছোৱালীজনীয়ে উক্ত আসামী কংকন দাসৰ সোয়েঞ্চো মোবাইলৰ ফোনেৰে কথা পতা মোৰ পৰিয়ালৰ মানুহে গম পায়। সেয়েহে মোৰ ছোৱালীজনীয়ে মৃত্যুবৰণ কৰাৰ মূল কাৰণ উক্ত আসামী বুলি সন্দেহ হয়। মোৰ ছোৱালীজনীক উক্ত আসামীয়ে আগতেও ফোন যোগে বিভিন্ন মেছেজ আৰু ধমকি।
You have not applied for bail.
I am on bail. I was granted bail. Charge sheet was given. I had appeared there. Charges were framed under 306. I have come against that.
Against the framing of charge.
Against the framing of charge, challenging that order and the entire proceeding. My lord, what has happened, if your lordship takes up the charge sheet that they have filed, that is at page 54, annexure 8. Last part of page 54.
Yes.
Last part of page 54, this is the facts they have stated who are the witnesses. My last part enclosed, 1 sketch map of PO, 1 PM report, 3 Caesar list.
One second.
My lord.
Yes.
Down below.
Yes.
Enclosed, 1 sketch map of PO, 1 PM report, 3 Caesar list, 1 dead body challan, 1 inquest report, and 1 bail bond.
Yes.
My lord, their allegation is, if the brother of the deceased, he also says that before she committed suicide, she was crying over the phone. Now, to connect me with her, that I was the person who was calling, CDR has to be there.
See, Mr. Bhattacharya, it is too early for quashing, correct?
I understand, my lord. There also,
Because
if
you are right, but we don't know what is going to come out.
yes, my lord.
And you are already on bail.
I am on bail, but my lord, proceedings has to be stayed otherwise. Because
We don't know what is, something may come up during the
Because my lord,
investigation.
there are judgments which said that if there's prima facie, you cannot even say that to connect the two persons, and if the deceased, she's hypersensitive.
There is allegation for connection.
But that's what my lord
My
is
daughter
saying.
used to call at so-and-so number of the above mentioned accused person through her mobile number so-and-so, which came to be known by my family. That is why I doubt that the reason for my daughter committing suicide is the aforementioned accused.
My lord,
So
yes,
there is,
yes, my
you
lord.
see, it can be vague, but investigation may reveal something.
My lord.
Tomorrow something may come out, so it is too early in
Investigation-
the day.
His 161 is there. His my page 21.
Page
21. The father, informants 161.
informants,
Yes. He's the father,
21.
page 21. Translated version.
Yes.
My lord, my name is so-and-so, so-and-so. Third line, my lord. 2 months ago, I came to know that my daughter was having
When
a
is
love-
the next date?
My lord,
Trial has started.
charge has been framed.
And
The
next
is
date?
26th of April for
26/4.
26/4. My lord, third line. 2 months ago, I
Then,
came...
Mr. Bhattacharya, we shall let me issue notice. We'll give you a date before 26/4 and on the and call for the LCR. Upon receipt of the LCR, the prayer for the interim order shall be considered. Heard Mr. D.K. Bhattacharya, learned counsel for the petitioner. Stop. Also heard M.S.A. Begum, learned APP for the state respondent. Stop. This is an application under section 401, read with section 397 of the Code of Criminal Procedure 1973, challenging the impugn order dated 3/2/2024 passed by the learned session judge Bojali in session case number 39 of 2023, framing charge against the petitioner under section 306 of IPC. Stop. In order to consider the prayer of the interim relief, this court is of the considered view that the LCR, scanned copy of the LCR be required. Stop. As accordingly, let the scanned copy of the LCR from the court of the Session Judge Bojali be called through the registry. Stop. Issue notice, returnable 2 weeks. MS A. Begum accepts notice on behalf of respondent number 1, registered post AD in respect of respondent number 2. List on after 2 weeks, 22nd 4/2024. Interim order, interim prayer shall be considered after receipt of LCR.
Obliged.
There is a stay order in this petition. Due to stay order, madam, the case has been pending, madam. We are suffering, madam.
Who is the petitioner?
It is not appearing, madam. You also may dispose the petition either way, madam. Either allow or dismiss.
Petitioner not there. Next.
The last 3 years, madam, the case is pending before the law court, madam.
Oh, it's of 21.
The Sheikh Bounce case, madam.
A.K. Roy.
Yes.
Yes, they are there. Yes. What is it?
In this case, my lord, regarding check bounce case, first the honorable magistrate ordered for forensic examination of the signature, and thereafter there some signatures was taken and that was sent to the FLC. But as it was not sufficient, the same was returned with observation that sufficient signatures has not been given. Accordingly, on the next date, I have given the 18th number of signatures. And then
the order of 17/2/21 is under challenge.
Yes.
What right has been affected? How?
Because, my lord, under CPC, my lord, under CRPC,
yes,
there is no provision regarding review.
There is no provision of giving
review of the order.
Which order has been reviewed?
Yes, my lord.
First of all, what has been ordered under section by this order? The complainant has submitted the original checks. 18 numbers, specified signatures are available. Pen card so and so submitted. Minutely peruse the purported signatures. It appears signatures as well as are identical.
Yes, page 13.
The case shall now proceed. Yes. Page?
Annexure B, page 12 actually, but relevant portion, page 13.
Yes.
Page 13, in this order, the learned magistrate has directed to send the 3 number of checks for forensic examination, whether the signature is of me or not.
Where is the forensic report? It has come or not come?
Yes, that came, but the observation.
Huh?
Yes, that observation in my affidavit. I have filed one affidavit.
Because on 17 you were absent.
Yes,
Complaint was absent.
Yes. Yes, my lord. Then your lordship come to my affidavit dated 13/9/21. Annexure F.
Page?
It is answer not H.
Forensic page.
Yes, page is, my lord. It's the one. Page 7, annexure H.
Page 7 is the prayer, Mr. Counsel.
Yes. Page 7 is also clear.
There's no page 7 in my
Annexure H, your lordship.
annexure.
H.
H.
Yes.
There's like 9.
Order dated 1910.
When provided there is an affidavit matter filed.
Yes.
There's
One
an
affidavit. One affidavit.
That was not provided to me. I'm sorry.
Not provided to you.
I have given. You have not collected.
Affidavit is not given.
Yes.
You give him the affidavit then.
You have not collected.
Mr. A. Khanikar, learned counsel for
Respondent.
respondent submits that the copy of the affidavit, additional affidavit filed by the petitioner has not been furnished to him. Stop. Let the same be furnished. List this matter after.
This is a very urgent matter from 2020.
You are saying otherwise we yes did you. Next.
I am for restaurant number 1, but restaurant number 2 is for.
Yeah, did it in March. 18/4, huh? Yes. Mr.
Other side, forest department.
Forest department. Restaurant number 2.
Showing in
Forest name is not shown, I think. Aibor Thakur. Aibor Thakur.
Yes, my lord.
LCR has come here.
LCR has come. This is what Miss Borthakur is not here. Wait for some time.
Item 19.
None appears.
First time.
Yes, ma'am. Criminal appeal. Appeal.
They will issue notice.
Yes, notice.
It's POXO. None appears when the matter has been called. List after 2 weeks and a date to be fixed by the registry.
Item number 20, case diary is received, but my post-mortem report is not available in the case diary. Post-mortem report is required, my lord, because the allegation is
one false allegation he has been dragged in this case.
Mr. P. Borthakur, learned APP for state respondent, submits that though the case diary has been received, however, the post-mortem report is not available therein. Stop. Stop. List this matter on short date.
2nd of April.
2/4/2024 for placing the post-mortem report.
Can be prior to that, Lordship.
Holidays are there, counsel. Next.
Item 22.
22 also, my lord, case diary not received.
This is AB.
AB, ma'am.
Await case diary. List again on
my lord, 9th of April.
9/4/2024. Interim order passed earlier shall continue till then.
Item 23.
23 also, my lord, case diary not received.
Yeah,
up to date case diary not received.
I'm already on interim.
Up to date, await up to date case diary. List again on
24/4.
24/4/2024. Interim order passed earlier shall continue till then.
Item 24. Item 24.
24 case diary received. Case diary received.
Case diary received, but petitioner absent. Let us keep this for some time since the case diary is there. It all commandary piece of petition.
Item 25.
In the meantime, you can
25
send the
minutes.
information to the council for if you know the council in item 24.
Yes.
Case area is called for lodge.
24 my lord, 25 case diary not received my lord.
25 case diary not received.
Not received my lord.
Await case diary list again on.
Interim asana?
Yes, there is interim.
Interim.
There's no.
On 3-4 my lord.
3-4. 2024.
Deeply obliged.
26-27 also my lord case diary not received. Petitioners are in inferior.
Yes. 26-27.
CD not received my lord.
26 and in 26 and 27. Await CD list again on 23/4/2024. Interim is there.
Yes.
Interim order passed earlier shall continue till then.
Deeply obliged.
28 also my lord case diary not received.
Are you on interim, Mr. Ahmed?
Lordship, I am seeking interim lordship to page the third date lordship. And lordship may kindly peruse the FIR lordship. It is a case of civil nature lordship. Page number 14 is the FIR lordship. One-fourth. May I read it, lordship?
That goat incident.
Yes, lordship. Our court.
Let him appear then, Mr. Borthakur.
Yes.
In item 28.
28, my lord.
Heard Mr. M. Ahmed, learned counsel for the petitioner, stop. Also heard Mr. P. Borthakur, learned APP for the state respondent, stop. Although case diary was called, the same has not yet been received. Stop. Reminder for case diary fixing on
my lord 25th of April.
25/4/2024. Stop. Next paragraph. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioners, i.e. 1 and 2 at page number 2. Now, there are 1, 2, 3, 4, 5, 6 and 7.
Yes.
7 petitioners.
6 lordship. 7 lordship.
7, right?
7 lordship.
7 petitioners at page number 2.
2, 3 and 4.
2, 3 and 4 shall be released on interim pre-arrest bail subject to following conditions. Arresting authority, that you see the format. Number 1, appear before the IO within 10 days.
Yes,
and the other 2 conditions.
Highly obliged.
List accordingly.
Highly obliged.
29 my lord scan copy was called for not yet received.
376.
Yes,
Reminder for scan copy of LCR from the Court of Learned SDJM S. Dhubri through the registry. List again on
23rd of April.
23/4/2024. Next.
30 my lord case diary not received.
Wait, please, your
376.
Lordship, matter may be passed over for the typing.
Case diary not received, ma'am. Await case diary. List this matter again on
3rd of April.
3/4/2024.
May I please, your lordship?
Yes.
Lordship, on last occasion, CD was called for most probably.
CD normally and scan copy of
Scan
LCR
copy
was called for.
of the LCR.
Yes, it has come.
Yes, my lord.
Yes.
Your lordship may kindly page 6 paragraph. Your lordship may kindly peruse paragraph 7, my lord. Initially, my lord, he was shown as absconder in the search sheet, my lord. Initially, my lord, interim granted by this honorable High Court.
And lordship, as per their interim order, I appeared bail bond submitted, but at no point of time IO either called me or the bailor. Later on, what happened? Search sheet file showing me absconder, which is totally wrong. Now, Lordship, my problem is that this case involves 376, which is pending
NBWA
before
issued.
SDJM.
My lord, here earlier order of your
No,
lordship.
right now NBWA has been issued.
Yes, NBW issued.
Then there is the decision of the Supreme Court and no anticipatory bail if NPWA
Yes.
and PNA has been issued.
Yes.
Banerjee.
And earlier also, my lord, while rejecting his prayer, my lord.
I applied bail
Last
application. Your
observation
Lordship
of
was pleased to direct.
Very well, Mr. Chamor.
Direct me to appear before the learned
Yes,
court
but
trial
then you
court,
did
but
not.
The learned trial court has no power to grant entertain such bail application under 376, which is pending before SDJM. That's why, Lordship, I again filed one IA, and your Lordship was pleased to direct me to file it afresh. Because through IA.
So thereafter, did you file?
Yes, Lordship. This is now fresh application. Earlier bail application was already disposed of. Lordship.
In Shrikant Upadhyaya, the Apex Court have clearly said no anticipatory bail when you default in your appearance and NBW and PNA are issued.
Yes,
But Lordship, I never remain absconder, Lordship. At no point of time, I appear before the IO. They have filed this charge sheet completely in a wrong way, whereas I appeared bail bond submitted, Lordship. Lordship may kindly appreciate my case, Lordship.
Which page?
Hello, your lordship, earlier direction of this honorable court, your lordship, paragraph page
Lordship,
6.
may kindly
Thakur,
just-
let him first submit,
Yes,
because
Lordship,
it is
may
very
kindly
difficult
just
to
peruse.
appreciate if both of you submit together.
Yes.
Lordship may kindly
Let him
peruse
finish.
only page number 20.
20, yes, I am at
Lordship.
page
This
20.
is the bail bond through which I appeared before the IO. My statement recorded. Thereafter, how the IO can file a charge sheet, Lordship, showing me absconder? I appeared. My statement also recorded.
Okay,
And this
and,
is the bail bond, Lordship.
And where are the orders of this court?
And now, Lordship, may kindly peruse your Lordship's order dated 24/1. 24/1, dated 24/1, page number, Lordship, 26. Page number 26. Got it, Lordship?
Yes.
In view of the above last paragraph, this court directs that the petitioner may appear before the learned trial court on the next day, that is on 7/3/2024, and upon his appearance, the trial court shall consider the prayer for bail.
So
in
when did
accordance with
you
law.
appear before the trial court?
But Lordship, the trial, this case was not committed till then, and it is pending before the SDJM, who has no power to entertain any bail
That is why you
application.
filed a subsequent.
Yes, Lordship. That's why I am filing it again. As per order dated, thereafter I filed a IA, Lordship, in that case, and your Lordship was pleased to pass the order, which is at page number 29.
That was withdrawn.
Yes. That IA was withdrawn because it is submitted that Lordship, through filing a IA, your Lordship's order cannot be modified.
Yes.
And
Then
I am directed to file it afresh.
Then?
Now my problem is that as the case is pending before the SDJM, I may not appear there because no bail application may be entertained in that court. Because
that is why you did not appear.
Yes, that is why I am not appearing.
And then what happened there?
And Lordship, I am praying for bail from this
What
court.
happened thereafter?
Lordship?
What happened thereafter? In the
Thereafter-
meantime, you appeared before the IO.
Yes, I appeared initially when interim order was passed at the very beginning.
Initially, in your
Yes,
AB,
I
there was an
appeared.
interim order.
Interim order, I appeared.
Where is that? Where is that?
Yes, Lordship may kindly peruse page number 17. 17, Lordship. Last paragraph, Lordship. Accordingly, it is order dated, Lordship, 15/10/2020. It is long back before 3 years. Accordingly, it is hereby directed
So,
that
in terms of this order, you had appeared
yes,
before the
in
IO.
terms of this order, I appeared before the IO, Lordship. My statement recorded, Lordship. And bail bond is also there, Lordship.
All right. Thereafter,
Yes, Lordship. Thereafter, Lordship may kindly peruse page number 21, the search sheet.
yes.
here, Lordship, I am showing as a absconder.
Which, where? Yes. This is on 31/7 and that bail bond is dated?
And Lordship may kindly see
Yes,
page
Mr.
number
Borthakur.
23.
My lord, your lordship may kindly see page 17, initial my lord bail application AB 2813, that is of 2020. In this case, my lord,
thereafter he appeared.
Lord, bail bond is there. Bail bond
if
is
he
there.
appeared, then why he again approached in the year 24, my lord, before this honorable court, my lord? In the year 24, my lord.
This bail, the earlier bail AB.
Yes, Lordship.
Yes, why did you again file, Mr. Shamuria? First of all, the interim bail that you had initially got is in AB 2813 of 2020, correct?
Yes, Lordship.
Then what necessitated that for filing the second AB? Second AB, which is AB 178 of 2024.
That was Lordship interim order. Later on, when case diary came, thereafter my bail application was rejected at that point of time.
Where have you said that and where is that order?
That order is not annexed.
Why is it not annexed? Because then AB 178 is a second application.
Yes, ma'am.
That was not submitted on the last occasion, Mr. Borthakur.
Yes, ma'am.
That fact was not brought before this court
Yes,
on the last occasion.
Yes, well,
and the current one is the third application.
Yes, yes, ma'am. And your lordship, page 26 earlier passed by your lordship. There is no mention about whether he is absconder or my lord.
Nothing is
only
mentioned.
Someone issued, my lord.
Correct. Because that fact was not brought in.
Yes, yes, ma'am.
Yes, you have not even. Where have you said that your first anticipatory bail application, where you had got interim order and thereafter you appeared before the IO, got your statement recorded, and subsequently after perusing CD, this court had rejected your AB? Where is that? Where are those averments and where is that order?
In paragraph 5, page number 5, paragraph 5, I state that the aforesaid anticipatory bail application bearing AB number 2813/2020 has been rejected by this honorable court by its order dated 21/12/2020 after perusing the case diary. After perusing the case diary, my earlier bail application was rejected. It is clearly I have mentioned, Lordship, in paragraph number 5.
And thereafter, after charge sheet was submitted, you approached again by second bail anticipatory bail application.
Yes. And it is in paragraph number 7, the second paragraph. However, the said case is still not committed to the proper trial court, and the said case bearing PRC case number so and so is pending before the SDJM, North Salmora, Bhoyapuri, and in accordance with
now,
law.
after charge sheet submission also, it is not committed.
Now, my lord, present position is that summons issued to the petitioner. There is no question of my lord case is committed or not committed. His ground is that
Summons issued from which court?
SDJM.
Now his case is that the SDJM will not be able to entertain the bail prayer.
Yes, Lordship. SDJM.
As 376 is there.
376 is
first
there.
let him get the instruction whether
If I appear,
whether the case my lord, now committed to the session court or not, my lord, the present my lord status. Let him get an order.
No. It is clear. It is clear. It is pending.
LCR is here.
Yes, it is clear. LCI is here. It is clear. Absolutely clear. Case is pending before Lordship, SDJM, and Lordship, my prayer is there.
Then let us let him be on interim. Let him with the condition that he shall appear regularly before the trial court.
Yes, ma'am, before.
Yes, Lordship.
Because now the case is ready for trial, isn't it?
Yeah, because my lord, he has not pointed out all these
Correct.
things.
That is why perhaps the earlier orders have been passed. Now, be that as it may, the liberty of a person is also a concern, and it appears that.
Yes, well, if he would have placed all these, my lord.
Anyway, since the investigation is completed, charge sheet has been filed. Earlier, his statements have also been recorded.
Yes.
So, this is item number 31. Heard Mr. G. Chamwal, learned counsel for the petitioner, Stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. This is an application under section 438 of CRPC seeking granting anticipatory bail to the accused petitioner, i.e. MD Omar Ali, alias Omar Ali, who is apprehending arrest in Mirichar Police Station case number 75/2020 registered under sections 448, 376, 511, 323, 34 of the IPC, corresponding to the PRC case number 932/2021 pending PRC case number 932/2021 pending before the SDJM M North Salmara at Abhayapuri. Stop. It appears that though earlier by ordered, should I record that or not necessary?
Not necessary, madam. Let him appear before the...
Stop. The facts of the case is that on 8/8/2020, while the informant was absent at home, the petitioner is one. The petitioner, along with co-accused, entered his home and tried to commit rape on his wife. Stop. Mr. G. Samuel, learned counsel for the petitioner, submits that the investigation is completed and charge sheet has been filed, and the petitioner is willing to cooperate in the trial. Stop. Mr. P. Borthakur, learned APP for the state respondent, opposes the prayer for bail. Stop. I have perused the aforesaid. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation has been completed and charge sheet has been filed. Vide stop. Further, it appears that summons has also been issued to the petitioner on 21/12/2023 for his appearance before the Court of Subdivisional Judicial Magistrate M, North Salmara at Abhayapuri.
Next date is 3/6/2024, Lordship. My appearance.
Considering the facts and circumstances of the case, this AV can be, this anticipatory bail application can be disposed of with the direction. Don't say disposed of. Is disposed of with the with the direction that it is provided that in the event the petitioner named above, in the event of his arrest in connection with the above noted case, shall be released on pre-arrest bail, bond of rupees 30,000 satisfaction
to the SDJM.
To the SDJM
within bracket M.
Within bracket M,
North Salmara,
Abhayapuri.
Yes, Lordship.
Subject to following conditions. Number one, shall appear before the trial court on all dates fixed time to time. Fixed from time to time. And the other one, inducement and refrain. With the aforesaid observation and direction, stands disposed of. Case return LCR.
Highly obliged, my lord.
Disposed of.
32, my lord, case diary not received.
Await case diary, list on?
On, my lord,
20, Lordship, it may be listed on 28.
4/4, my lord.
4/4/2024. Case diary?
34, case diary received, my lord.
306.
My lord, abatement to commence, my lord.
FIR?
My lord, base 10 is the FIR, my lord.
My lord, in this case also, my lord, post-mortem report is not available, my lord.
Consuming pesticides.
Yes.
Lordship will see the FIR, my lord. I have taken the victim to the hospital, my lord. I have taken all care, my lord. And allegation was raised by...
Let him appear then.
Otherwise, my
On
lord,
11th March, we had called for the case diary.
yes, my lord. CD received, but my post-mortem report in the case diary is not available. My lord.
Disposed of or?
My lord, any short death, my lord. Short death, my lord, because there is specific allegation, my lord, against that in his shop, my lord, electronic shop.
The allegation is suicide.
Suicide.
Committed suicide because of the love relation.
Yes,
It
my lord.
appears
Otherwise,
that
the accused person also
the
taken
accused
heart, my
and the
lord.
deceased had a history together.
Yes. Yes, your lordship, my lord. Otherwise, my lord, victim committed suicide.
Heard Mr. A.K. Gupta, Learned Counsel.
R.S. Mishra,
Sorry?
R.S. Mishra, my lord.
R.S. Mishra. Heard Mr. R.S. Mishra, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, Learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting privilege of pre-arrest bail to the petitioner, i.e. Shri Songkhram Koiri, alias Shri Sangram Koiri, who is apprehending arrest in connection with Moran PS case number 19 of 2024 corresponding to GR case number 216 of 2024 registered under section 306 of IPC. Stop. The case of the prosecution is that the petitioner and the deceased had an history together and thereafter they had a fallout as the deceased started seeing another person. Stop. It is the further case of the prosecution that on 21/2/2024, while the petitioner was in the market, he found the said deceased No, delete that portion, the last sentence. It is the further case of the prosecution that on 21/2/2024, since the informant's sister did not return back from the market, upon inquiry being made, the informant came to know that she attempted to commit suicide by consuming pesticides. Stop. It is the further allegation of the prosecution that the petitioner committed by giving allurement of love, committed physical and mental harassment upon her, for which she had consumed pesticides. Stop. Mr. R.S. Mishra, Learned Counsel for the petitioner, submits that after that on 21/2/2024, while he was passing through the market, he saw the deceased lying in the market and accordingly took her to the medical center and also informed her family members. Stop. Mr. P. Borthakur, Learned APP for the state respondent, opposes the prayer for bail, anticipatory bail. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the petitioner and the deceased had a history together, and after their relationship did not work out, after their relationship had for what is shown in the CD?
Initially, they both were in love, my lord. Later on, my lord, accused, as per the statement of the other witnesses, accused in love with someone other, coming to know about the same, the victim came to the electronic shop of the present petitioner, and in presence of all in the daylight, she consumed pesticide. And thereafter,
it further appears from the materials available. It further appears from the statements of the witnesses recorded by the investigating officer under section 161 CRPC during investigation that the petitioner has later on broken all terms with the petitioner, with the deceased, and for which the deceased had visited his shop and in the presence of other witnesses had consumed pesticide. Stop. Considering the considering the facts and circumstances of this case, this court is of the considered view that custodial interrogation of the petitioner may not be required for the ongoing investigation. Stop. On top also you say, it further appears that the investigation has substantially progressed. Correct, Mr. Borthakur?
Yes, sir.
Then you say, in the event it is provided, accordingly it is provided that in the event of arrest of the petitioner named above, in connection with the aforementioned case, he shall be released on pre-arrest bail, bond of rupees 30,000, satisfaction arresting authority, subject of course to the following conditions. Number 1, appearance within 10 days. 10 days. Inducement, refrain. With the aforesaid observation, this AB stand disposed of.
My lord, it may, although my lord, though witnesses daylight, my lord, at that point of time other persons were present, but in presence of witnesses, my lord, probably she has not consumed the pesticide because later on pesticides were not recovered, my lord.
I'll edit
so
it.
that may be, my lord.
But you said that
yes, she consumed poison later on, all in presence of, my lord, in that electronic shop, my lord. Later on, everyone came because in the daylight, my lord,
very well.
she consumed, but
very
not in presence of
well.
witnesses.
I'll edit it, Mr. Borthakur, later.
In this case, Counsel D. Kukoi has the records of the confiscation proceedings. We just seek 1 week time, Lordship.
Are you? This is what? Criminal petition?
Yes.
Criminal petition, 482.
Why 1 week? Alright, 1 week they want time. As prayed for by Mr. I. Borthakur, Learned Standing Counsel for Respondent number 2, which is not opposed by Mr. P. Borthakur. No, sorry. Your name?
S. Rahman.
S. Rahman, Learned Counsel for the petitioner. List this matter again on?
Any date after we
10/4/2024.
Within first week, my lord. Earlier matter also fixed first week matter. That matter also. Item number 11. That was item.
That is a different matter.
No, same matter, my lord.
Same matter.
Same matter.
Related matters.
Related matter. Item number 11.
When did this court fix item 11, Mr. Counsel?
First week.
All right. Same day.
Obliged.
First week of it. To be fixed by the registry. Next one to 24. CD is there, Mr. Borthakur?
Yes, my lord. Case there.
Yes, Mr. Laskar. You appeared?
Yes, my lord. Appeared.
Statement recorded.
Yes, sir.
Anything?
Cooperating with the investigation.
Cooperating?
Yes.
Any adverse material?
Otherwise, he is cooperating with the investigation on that job.
Heard Mr. F.Z. Majumdar, Learned Counsel for the petitioner, also heard Mr. P. Borthakur, Learned APP for the state respondent. Stop. This is an application under section 438 of CRPC seeking anticipatory bail of the petitioners, i.e. Najuk Uddin Lokor, who is apprehending arrest in connection with Karimganj PS case number 28 of 2024 registered under section 419-420-376-313 of the IPC. Stop. This case diary called for is placed before the court. Stop. Pertinent to mention herein that by order dated 22/2024, this court granted interim pre-arrest bail to the petitioner subject to conditions. Stop. It is submitted by Mr. P. Borthakur, Learned APP for the state respondent that the petitioner has appeared before the investigating officer and has got his statement recorded under section 161 CRPC. Stop. He further submits that the petitioner is cooperating with the investigation. Stop. Considering the aforesaid endorsement made by the learned APP, this court is of the considered view that further that custodial interrogation of the petitioner may not be required at this stage. Stop for the ongoing investigation. As such, it is provided that the interim pre-arrest bail granted by order dated 20/2/2024 is hereby made absolute, subject to conditions. Cooperate. Disposed of. Yes, Mr. Das.
I need 4 weeks time to find a dusty service below.
Await service, otherwise is awaited.
No,
you have taken service.
Yes, we have taken
heard Mr. N.C. Das, learned counsel for the petitioner. Stop. It is submitted at the. Don't say it is submitted. Mr. Das submits that he may be allowed 4 weeks time. 4 weeks time. 4 weeks time to file the affidavit of service. Stop. Prayer allowed. List after 4 weeks on a date to be fixed by the registry.
Much obliged.
This matter was earlier posted for hearing, Lordship. NCR also has been received.
Why is it for orders? LCR has come. So this can be posted for hearing?
Lordship. For hearing after.
No name has been, there is a private respondent, I think, but no name has been shown.
Service is awaited.
Service complete. Service completed. My learned friend says service is complete. Then it can be released for hearing.
It's a POXO matter.
Not though it is POXO, but punishment is under 354. Case was registered under POXO.
Initially registered under POXO.
POXO no conviction one.
Convicted under 354.
Listed for hearing after
there is no judicial order indicating that service has been completed. Corresponding file ata ase niki?
Service complete hobole kotha.
Maitri corresponding file ase. Corresponding file ase niki? Etu ta report boli koise. Flag SR. Unto SR flag nai. Na? Beleg file ase. Can yet so it is await. No? Mr. Counsel, just wait for a minute because I do not find the report. What is this IA for?
IA for
suspension of sentence.
Sentence and grant of bail.
10 years punishment, my lord. We have filed objection to the IA.
This is NDPS.
NDPS.
Lordship.
You have filed your objections?
Yes. 38 kg ganja was recovered from his possession, from his house.
Regards of 37 is applicable.
My lord.
Yes, what is the case?
The case is that on FR is on page number 56.
IA. 56 kun
56?
FR is on
yes.
page number 56.
Yes, please read.
In enclosing herewith the extract copy of Mazbat PS GD number dated I beg to state that today on 12/3/22 in the early morning on the basis of secret information Sent ASI Amirul Islam along with OC Mazbat PS and staff obtained permission from Circle Inspector Rota and conducted a search operation in the house of Sri Bunu Sargari, son of so-and-so of village so-and-so under Mazbat PS.
Counsel, read slowly, don't be nervous. Read slowly.
Recovered a polythene bag consisting suspected of cannabis, ganja, and it has been weighted at the PO in presence of the witnesses and found 1.180 kg cannabis from his possession and duly seized.
So this was possessed from his possession means
from
the petitioner.
Bunu Sargari.
Bunu Sargari. Actually, the information I am submitting on in nutshell. Information was regarding Bunu Sargari. He was
regarding
Bunu Sargari. Now, appellant is not Bunu Sargari. He is now from Bunu Sargari's house, 1.180 gram was recovered, ganja, and he led to this appellant.
He led to the appellant. What is the role of the appellant? How? What is the? How he has? Was he in control of the contraband articles that were seized from the house of the co-accused? Conscious possession, how has been shown?
No, maybe they have.
Not maybe, Mr.
Mr.
Das, because 37, this court has to be prima facie satisfied that the case has been made out.
Yes.
And if that's so, then this court is not going to grant bail. However, if this court is of the view that the materials that has been collected is not sufficient for making out a case, then of course, that is the rigor of 37,
now,
isn't
Bunu
it?
Sargari, when recovery was made from Bunu Sargari, on interrogation, Bunu Sargari led the team which came to for search in his house to this.
So statement of co-accused?
No, not co-accused, Sanjit Gari. From Bunu Sargari, the police had information that Sanjit Sargari, the present appellant, is also concealing, doing this business. Then they, taking Bunu Sargari, went to Sanjit Sargari's house and recovered 38 point.
Where are those findings? Because the trial court has already convicted.
Convicted, yes.
So where are those findings before the trial court?
Yes. Judgment starts at Milord. The contents of the judgment starts at Milord 24 page of the IA Milord. Then all these Milord up to page 34 Milord, evidence has been discussed.
Yes, where are the findings against the petitioner on the basis of which a conviction was made? You are aware of the rigors of section 37 of the NDPS Act? Yes.
Now my lord will come to
yes, counsel.
Page 46.
Yes.
Page 46. The citation is given below. Para 20, internal para.
That
in
is,
the case of Dharampal Singh,
this
is regarding
Mr. Das, I'm only asking a very simple question. What is the finding of the trial court against the petitioner on the basis of which a conviction has been made?
Page 48.
Yes, Miss Counsel. Do you have that page or not? Are you prepared or not? Otherwise, we will take another date. You all are taking a lot of judicial time if you are not prepared.
Lordship,
Where is that finding of the trial court? You are seeking for bail, you must be knowing.
Page 48, Para 37.
Yes.
Considering the evidence on record of the instant case, it is found that the prosecution has already discharged the initial burden which rests upon the prosecution because the PWs have stated in their evidence that house of Bunu Sargari and Sanjit Sargari were searched duly and thereafter the contraband was recovered from their houses. At the time of at that time, the accused Bunu Sargari and Sanjit Gari were found present in their respective houses. During the
The
cross
present
examination,
petitioner is Sanjit Gauri.
Sanjit Gauri.
So so from para 37 it appears that even the house of Sanjit Gauri was searched and contraband articles was recovered from his house as well.
Yes, yes.
Correct?
Yes. 38 kg.
Yes.
30 and odd kg. During the cross examination, nothing much could be derived to demolish the evidence of PWs. Para
So
38.
from Sanjit, 38.320 kg contraband.
Yes, yes.
Rajiv
That is
Narsari,
commercial
nothing
quantity.
has been.
Commercial quantity.
So this appeal is by
Sanjit
alone.
But the Lordship,
One second. What was the offence? The section is 20
Commercial quantity
to
of-
see commercial quantity. Yes, there are findings and there is nothing wrong. It appears that the petitioner is guilty. In fact, there is a you see, even pre-conviction, the rigors is that if the court thinks there is a prima facie case, the court is not going to grant bail. Correct? Now this is, you are coming after post-conviction, where already convicted upon finding that there are materials against you.
Lordship, the PWs which they have produced, PW1, the ASI, Amirul Islam prepared the scissor list, Lordship. The scissor list is Mili Goyari. PW2 has clearly stated in her evidence that about 8 months ago, police arrested my husband. Actually, she is the wife of Sanjit Goyari. But police did not disclose the reason for arresting her husband. And afterwards, she was declared hostile. During her cross, she examined by the accused, she stated that nothing has been shown by police to her at the time of obtaining her signature. Nothing was recovered from her house. And signature was obtained her signature was obtained
In this
in the
case,
police
LCR has already come, right? So then we post it for hearing.
Entire matter may be heard, you know.
Let the matter be heard.
Because to dispose of the IA matter, we have to go to the minor details of evidence on record.
So shall I dispose of the IA?
My lord, let it be pending, my lord.
Lordship, there are sufficient materials that
Well, a hearing will be required. This IA cannot be disposed of like that. If you want, I can dispose by rejecting your prayer and post it for hearing, or I post the entire matter for hearing. Discretion is yours. What do you want?
if the Lordship is waiting for LCR, actually in the similar matter, in the same case, another accused is there, is Bulu Sargari, and his matter has been fixed in London Justice P.J. Sekia Court tomorrow, Lordship. And LCR has already been...
No, we are posting it for hearing. It appears that the criminal appeal is ready for hearing. Stop. Let the criminal appeal along with the IA be posted for hearing on...
After view, madam?
No, Lordship, before...
Give a date. Give a date. Fixed date. 2/5/2024. It is 36 আছে না? আছে? So this is not submitted. So he has
Service complete.
এটা আছে না? No? In item 36, you see, it appears that the service on respondent number 2 is completed. Stop. Admit and post it for hearing.
No, admission. Admission. It is perhaps already.
Mr. P.K. Das.
Heard Mr. P.K. Das, Learned Counsel for the petitioner. Also heard Mr. P. Borthakur. Mr. Borthakur, you are there? Yes. Mr. P. Borthakur, Learned APP for the state respondent. Stop. This is an application for condonation of delay of 38 days in filing the connected criminal appeal.
Yes.
Stop. Issue notice returnable 2 weeks. Mr. P. Borthakur accepts notice respondent number 1. Steps by registered post in respect of respondent number 2, list accordingly.
Oblige.
None appears for the petitioner when the matter is called. List after 2 weeks on a date to be fixed by the registry.
May I please service upon respondent number 1 is awaited.
Await service report. List after.
There is an observation of the Honorable Court. They may be considered on today, on last order.
Yes, but steps is, service is not yet completed, Mr. Counsel. Await service report. List after 2 weeks on a date to be fixed by the registry.
Oblige.
What is this IA?
Yes, Lordship. The Honorable Court directed the petitioner to appear before the Learned Court of Session, Vishwanath. But the Lordship, the instant case is pending in the.
I cannot hear you, Counsel.
Lordship, JMHC Court, Eleka Magistrate, JMHC Court, Vishwanath.
By inserting the words, the Eleka Magistrate.
Eleka Magistrate.
In which order?
Order is Lordship. Page 6.
Mr. Borthakur?
Yes,
So, these words will be after when? After, in the order, at page 7, it is mentioned, produce the petitioner before the district session judge so and so. Instead of district session judge Vishwanath Chariali,
yes,
it has to be Eleka Magistrate GMFA. Counsel,
in place of district and he needs to appear before the jurisdictional magistrate.
So in place of the order of 7, the order of 11/3/2024 has to be modified to the extent that instead of district session judge so and so, it shall be correct.
Yes.
The Eleka.
My lord, CJM Vishwanath Judicial Magistrate first class Vishwanath.
All right. Heard MS Tun Rajkwa.
Yes.
T. Rajkwa, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, Learned APP for the state respondent. Stop. This is an application seeking modification of the order dated 11/3/2024 passed by this Honorable Court in bail application number 418/2024. I've heard the submissions made at the bar and have perused the grounds for modification. Stop. In the interest of justice, it appears the order dated 11/3/2024 is modified to the extent that instead of district and session judge Vishwanath Chariali, it shall read as the Magistrate JMFC.
Yes, ma'am.
As Magistrate JMFC Vishwanath Chariali. Correct?
Yes, ma'am.
So and so in the said order. Stop. Accordingly, application allowed. Disposed of. Why is this for orders?
Orders, this IA is for extension of period of appearance.
Huh?
Extension of period of appearance.
Extension of time.
Extension of time, Lordship. Lordship, time is page 45, Lordship.
The order, Lord, impugn order. Page 46 is there. He is supposed
Yes.
to appear on 8/1/24, Lordship. But on that particular date, Lordship, the father of the petitioner expired, Lordship. So he could not appear, Lordship.
Where have you said that on 8/1 the father of the petitioner has expired?
Page 7, paragraph 7, Lordship.
Para 7.
Paragraph 7.
And you filed this application when? When was it filed? 3/3.
That due to some defect, Lordship, the matter was not listed, Lordship.
Uh,
So now the matter is fixed 19/4.
Before the next date of appearance is
19/4, Lordship.
19/4.
So I may be allowed to appear on that, Lordship.
Yes, let them appear on 19/4. Thereafter, trial court will consider.
Heard Mr. A. Sharma, learned counsel for the petitioner, stop. Also heard Mr. P. Borthakur, learned APP for the state respondent, stop. This is an application for extension of time provided in the order dated 19/12/2023 passed by this honorable court in AB number 3242/2023 registered under section 438 CRPC. Does this court has the power? The AB, there is no time for extension.
Otherwise, as per the earlier order of this honorable court, he is directed to appear before the trial court on 8/1/24 because of some minor difficulty probably on that can be extended, my lord.
All right.
But thereafter, my lord, trial court will...
I've heard the submissions made at the bar and have perused the materials available on record. It appears that by order dated 19/12/2023, this court directed the petitioner to appear before the trial court on 8/1/2024 for seeking regular bail. Stop. However, it appears from paragraph 7 of the efforts of the application that the petitioner could not appear on 8/1/2024 for before the trial court, as on that date the father of the petitioner expired. On that date only.
Lordship, in fact, Lordship, this matter was handed over to me on 12 February, Lordship. But myself has an operation, Lordship, on 14.
Anyway, stop. Stop. It appears that there are sufficient grounds averred in the IA for which the petitioner could not appear before the trial court on the stipulated date. Stop. Accordingly, in the interest of justice, this court extends the time of appearance and by directing that the petitioner shall appear on the next date, i.e. 19/4/2024, before the trial court. Until then, the interim order passed earlier shall continue.
And thereafter, the trial court will consider in accordance with...
As and when the petitioner appear, the trial court is at liberty to proceed therefrom in accordance with law. I disposed of. Harasa. Mr. Das, I shall just resume in 5 minutes. Yes, Mr. Das.
My lord, a CD is here, and the co-accused were granted bail, anticipated bail, on the day before yesterday.
Order?
Day before yesterday, Friday.
By this court?
This by this court.
Yes, the same submission, Ms. Begum.
Lordship, the thing is that, Lordship, there is a statement of IO's note, Lordship, where this person's name are that, but he have said that জড়িত ঘটনাৰ লগত জড়িত আছে যদিও অপৰাধৰ কৰাৰ পদকীয়াগণৰ বিৰুদ্ধে সাক্ষী জবাববন্দী
So there are no materials.
No materials.
So there are no materials against the petitioner.
That is
okay, not collected.
Lordship, they will record their statement, Lordship. That will we can see, Lordship. Because this CD again, this will come with a lot of Lordship.
So the other one is disposed of. This will dispose it of. Will appear. Both same.
But they will record their statement within 15 days.
Yes.
We have given 7 days.
There's 7 days.
So Ms. Begum, you wanted to make it 15 days?
No, Lordship, 7 days.
All right. So both 13 and 14 disposed of. Same. Everything I think Mr. Das will remain same, right?
Yes.
Except the name of the petitioner.
Yes.
And Lordship, my objection will be recorded, Lordship, because serially they will come.
You see, Ms. Begum, I don't think there is any objection that you have given because from the materials, you have clearly said that at this stage, so we last time also we have recorded that you have fairly submitted that on the basis of materials available in the case diary that the investigating officer has not collected any adverse materials at this stage against the petition. That is a fact. Then what is to object if there are no adverse materials?
So many accused, Lordship, serially they will come.
Because of that, would you oppose to the curtailment or would you suggest that the liberty of the petitioner be curtailed against whom there is no adverse material? That cannot be. You are also officer of the court. Same, 13 and 14. All right, dispose of. Yes, Mr. Das. Mr. Das?
There are 3 petitioners in the case.
3 petitioners in which case?
In both cases. In both cases.
In both cases there are total 3?
Total 6, Lordship, in both.
All right.
Much obliged.